Welcome to Business Line's State of the Economy podcast, where you'll find insight, analysis, and the story behind the numbers.
Hey there, welcome to the BL State of the Economy podcast. I am Shrivats from Business Line, and today we have a very interesting topic at hand, which is CCI's draft settlement and commitment regulations. The Competition Commission of India recently issued draft regulations for settlements and commitments framework in the public domain for stakeholders' feedback. This is part of the government's larger objective of ensuring faster market corrections. These two sets of draft regulations have been prepared by CCI in tune with the recent changes effected in the Competition Act earlier this year. The draft settlement and commitment regulations for the Indian competition law represent a significant development in the country's legal landscape. These draft regulations aim to streamline and enhance the enforcement of competition laws in India. Business Line spoke to Samir Gandhi, partner and co-founder Axiom 5 Law Chambers, in our BL State of the Economy podcast to get a deep dive into the proposed settlement and commitment mechanism, its comparison with the foreign jurisdictions, and understand from his perspective the disappointments, if any, at the draft stage. Welcome, Samir, to the State of the Economy podcast. To begin with, I would like you to help us understand what exactly is a commitment and what exactly is a settlement, and how do you see them being the sort of game changer in how corporates view it, and how is it going to make life easy for corporates?
It's always a bit difficult when you ask a lawyer to break down things, but let me give that a shot. I think to start with, you're absolutely right. The settlements and commitments mechanism, which was, of course, introduced through the Competition Amendment Act of 2023 earlier this year, is in many ways a game changer, Shivats. The reason why I say this is because for the 13 or 14 odd years of competition law enforcement in India, what had begun to happen was it had become highly litigious. It was very contentious. There were some very high stakes matters which were stuck in protracted appeal before the National Company Law Appellate Tribunal, before the High Courts, before the Supreme Court, and it was taking, anywhere between 7 to 11 years, in fact, even more in some cases, to actually address the market issues that were being raised in these cases. So there was a very formalistic system of an information being filed, the CCI investigating, finding a contravention, imposing a penalty, and then it was really being stuck in a situation of limbo. Now, what the settlements and commitments mechanism does in that context is really to introduce a method through which, instead of going through this protracted litigation and system by which, the penalties are recovered and the markets are actually corrected, it allows the parties who are being investigated by the Competition Commission of India to go forward and suggest to the commission that, look, let us try and arrive at a mutually agreeable solution whereby markets can be rectified, and we will assure you that we will change our behavior such that, there is no protracted litigation, markets are corrected quickly, and it is in many ways, Shivats, a win-win for both the regulator and the regulated. So I think it is very much a game changer. It is something that was raised in the Competition Law Review Committee, in 2019. And thereafter, both the Standing Committee as well as the Union Parliament thought it fit to introduce these provisions. And of course, now the Competition Commission of India has recently circulated a set of draft regulations. The regulations will be the nuts and bolts which tell us how you can offer a settlement, how you can offer a commitment, what are the terms for you to do so, so on and so forth. So that, in a nutshell, is what the settlements and commitments mechanism for competition law is aimed at achieving. Srivats.
Great. Thank you, Samir, for that. For the benefit of our listeners, can you deep dive into what is the difference between settlement and commitment?
Absolutely. So that's a great question. And I think, again, one has to take a step back and look at what the intent of this mechanism is. The intent, of course, is to allow parties during the course of an investigation to actually come to the Competition Commission and arrive at some sort of a mutually agreeable situation or a settlement or a commitment. Now, what happens here is that at the time at which the CCI's investigation commences, parties have only a commencement or what we call an initiation order where they know that they are being investigated. The commitment mechanism allows parties to come forward and suggest to the commission that we note that you have started the process of an investigation. Instead of going through a protracted investigation, we note that there are some competition concerns with our behavior, and let us try and arrive at a mutually acceptable solution to these allegations. And the party will offer a so-called commitment such that the CCI may either agree to accept it or disagree. But it's important to note that the commitment mechanism, the gun is fired in some sense. The starting point for offering a commitment is from the initiation of a CCI investigation. And the current draft regulations allow a party to offer a commitment until 45 days from the initiation of this investigation, with a potential grace period of another 30 days. So that's 75 days from the date of starting an investigation. Parties can offer a commitment. Important to note here, however, that this 75-day period has come in for some criticism, but we'll come back to that in a moment. So to start with, commitments can be offered at the time at which an investigation is initiated, contrasted with a settlement. A settlement can be offered once the Director General has completed its investigation, has invariably or variably found an infringement, and before the matter is finally heard and concluded, i.e., the commission actually arrives at a formal finding of infringement, parties have another bite at this apple. They can go to the commission again and saying, yes, we did not think that we required to offer a commitment, but it seems that the Director General, after its investigation, has arrived at some kind of a finding that there could be a contravention. Before the commission finally determines whether there has been or there has not been a contravention, let us offer a settlement. And here the difference between a settlement and the commitment which you could offer earlier is that the settlement is incumbent on the payment of a certain settlement fee. So the parties needs to provide a certain fee to the Competition Commission. And in addition to that, they obviously need to change their business behavior, which, for example, the Director General may have found to have contravened the provisions of the Act. So in a nutshell, again, Srivat's key difference between settlement and commitment is really the time at which you offer a commitment, which is before the completion of the DG's investigation, or a settlement, which is after the DG's investigation, but before a final finding of infringement. Secondly, a commitment does not entail any payment of any fee. it is a unilateral or a negotiated settlement arrived at to address a competition law issue, whereas a settlement involves the payment of a certain fee and as well as change in the corporate behavior. So that in a nutshell is the difference between these two.
Now, there is a perception that CCI has been quite progressive in not requiring admission of guilt to opt for a commitment or a settlement. What is your take on that, and how is it significant?
Yes, Shivats. I think the confusion here comes from perhaps a reading of the provisions of the Amendment Act contained in the Competition Amendment Act of 2023, wherein Section 48A, subclause 3 of the amended Act, which of course covers settlements, seem to suggest that the Commission would, at the time of considering whether to settle a matter or not, look into the nature, the gravity, and the impact of the contravention. So the word used in section 48A subclause 3 was for a settlement, there is a possibility of a contravention, right? That is, of course, to be distinguished, which the provisions of section 48B, which speaks about commitments, and the corresponding subsection there uses the word the impact of the alleged contraventions. So some commentators had, on a reading of the provisions of the Competition Amendment Act, had actually suggested that the distinction, therefore, between settlements and commitments was that a settlement would involve a contravention, i.e. an infringement, and a what you may call it, a commitment would be an alleged contravention. In other words, there was no actual finding of infringement. However, the Competition Commission, and I believe quite rightfully so, has in the draft regulations on settlements made it quite clear that the nature of a settlement is not or does not require any admission that there has been a contravention. The reason why I think that that's particularly useful is, bear in mind, Shrivats, and I know we didn't really touch on that earlier, but bear in mind that an order of settlement, unlike, for example, a commitment, is or can be the subject of a claim for compensation, right? So under section 53N of the Competition Act, settlement orders, so where parties have settled, and this is a key distinction actually, which I omitted to mention earlier, where parties offer a settlement, these are open to follow-on claims of compensation by those who are affected by such an order. Now, that is contained in the newly amended section 53N. So the reason why I think it's particularly useful that the Commission has clarified that a settlement does not require an assessment or an admission of guilt or of contravention is because there is a separate category which is created under section 53N for orders under section 48A. To put it simply, Shrivats, without splitting hairs as we lawyers tend to do, awarding compensation now has two categories. A, if you have committed an offense under the Competition Act. B, if you have arrived at a settlement order, which is not technically speaking a contravention of the Competition Act, you are still eligible to claim compensation from the so-called party who has offered the settlement or alternatively has contravened the provisions of the Competition Act. So I think the distinction is quite clear between section 48A and 48B regarding the need to assume that there has been some contravention. It's now very clear that there is no contravention which is required. And I think the draft settlement regulations are a welcome or provide a welcome clarification in that regard. giving the slightly confusing language contained in the statute itself.
You feel it's a progressive move vis-a-vis what other jurisdictions have laid in this regard?
Certainly, Shivats, I think it is at the end of the day, of course, we need to look at global practice, but I think there is a larger context here, even in India. We need to make a settlement something which is attractive to a party offering the settlement. We have to incentivize parties to go for a settlement. If there was a clear admission of guilt or of contravention, I think parties would think long and hard before offering a settlement agreement. They would rather litigate this before courts, which is exactly what the Competition Commission wants to try and avoid, as do parties.
So, I mean, I'm playing the devil's advocate. Do you think it will close the door for class action against corporate misconduct?
No, on the contrary, Shivat, I would have agreed with you had it not been for the amendment also to the corresponding provision which allows, I would hesitate to call it class action, but I would certainly call it compensation litigation, right? I agree with you. It would have closed the door for awarding compensation had it not been because, of course, before the amendment to the Competition Act, you could only claim contraventions where the Competition Commission had found a contravention. Right? Now, if you remove the finding of contravention for a settlement, then you're right. The door would have closed for any kind of compensation claims from a settlement application. But instead, the framers of the Competition Act have taken care to include specifically, by reference through amendment, Section 48A. So you see, Shrivats, even though 48A, which talks about settlements, no longer requires a finding of contravention, orders of settlement can still result in awards of compensation under Section 53N because of the amendment made to that provision. So I think this is a bit of a misnomer. I don't think that, even playing the devil's advocate, as one should by all means when looking at amendments to the law, one must look at this from the perspective of both the regulator and the regulated. I strongly believe that because of the amendment, this has not closed the door to claims for compensation from settlement applications. I think that, in fact, has been built in through amendment.
So one of the issues which need some clarity, I suppose, is can settlement and commitment orders be challenged before appellate forums?
The reason why the Competition Commission has, and in fact the Government of India has introduced these provisions is to preclude the protracted litigation. Now, it's the same thing. Now, if you think about conventional litigation, we had introduced arbitration. Arbitration clauses were a form of alternate dispute resolution whereby you did not get stuck in the logjam of courts, right? So it's an alternative channel altogether. Similarly, the settlements and commitments process would indeed get stuck in the very same logjam of appellate review and subsequent Supreme Court appeal, etc., if the orders of settlement or commitment were subject to appeal. So I think there is a delicate balancing act over here, where both the commission, the parties, and the public need to acknowledge that at the end of the day, there is something to be said about parties quickly changing their behavior, paying the penalties, and changing the conditions of the market, rather than litigating it through appeal and thereafter that in the Supreme Court, which can take anywhere between 10 to 11 years. The early cases, including, cement cartel, DLF, etc., these are all still stuck in before the Supreme Court in appellate review. So I think there is a strong public policy imperative which requires settlements and commitments to terminate legal proceedings if they are satisfactory for both the commission as well as for the parties. And incidentally, Shrivats, if you are a third party and if you are affected by a so-called settlement order or for that matter, a commitment that has been offered, Bear in mind that the law and the regulations allow the CCI to seek comments from third parties and the public at large before finalizing the commitment and settlement. So if you are a third party and if you are concerned that the settlement or the commitment will still not address your competition concern, then you will have a voice. However, that voice does not extend to appealing an order to an appellate court and thereafter the Supreme Court, because that would defeat the very purpose for which this entire mechanism has been created.
So, in sum and substance, the access to an appellate forum is not there.
The access to an appellate forum is not there from an order of settlement or commitment. That is correct. And as I mentioned, this is in keeping with the philosophy of why one introduces such a mechanism in the first place. It is to truncate litigation, not to extend it.
Got that. Yes. Will this framework apply for pending inquiries?
No, thank you, Shivats. And that is an excellent question. This is something that has occupied personally my mind as well. And at the time at which the act itself was framed, we had done some research on this aspect and considered that this was certainly something that needs to be addressed. And let me tell you why. As your question kind of indicates, the ability to offer, for a party to offer a commitment, ceases, if you were to go by the draft regulations, 75 days after the investigation has been initiated. If you were to go by the act itself, it would cease on the day on which the parties receive a copy of the Director General's report. In any situation, the ability for a party who is currently being investigated between, for example, April of 2023 and we are now in October of 2023, right? The moment they either receive the Director General's report or the moment that 75 days has concluded from the day on which the investigation started, they become ineligible to offer a commitment. This leads to a slightly anomalous situation whereby, as a party, you know that the law has been amended from April. You know that technically speaking, you have a statutory right and an enabling provision for you to be able to offer a commitment. But simply because the law has not been enforced as yet, in other words, it has not been notified, you lose that ability because either your 75 days has concluded or you have received a copy of the DG's report. Now, it is to address this, slight unfairness. And bear in mind, this is equally unfair to the Competition Commission because the Commission itself might be willing to consider commitments in several ongoing, investigations. So it is, I think that, a case should and can be made for some sort of a grandfathering provision whereby any investigation which was ongoing at the time at which the Competition Amendment Act was signed and passed by both houses of Parliament in April, any such investigation should continue to have the party should continue to have the right to provide a commitment in those investigations, even if 75 days has elapsed or they have received a copy of the DG's report. It's a one-time kind of transitional benefit which is available because of the lag between enactment and notification or enforcement of this particular act. So I think that would be keeping in spirit with what the Parliament intended. That would also entitle both the Commission as well as parties who are being investigated a right to offer commitments and not simply go by the formalistic date contained, in the regulations and in the act. So I do genuinely think that such an enabling provision is much needed.
So can this be introduced at the subordinate legislation level in the regulations?
Indeed, it can be, Shrivat. I think, there are many ways in which this can be drafted. One of them would be a simple extension of time or eligibility, in the current regulations, whereby, investigations which were ongoing, or the date of the enactment of this amendment in 2023, all such investigations may continue to provide commitments, notwithstanding the lapse of the 45 plus 30-day timeline contained in the regulations, or hopefully that 45 plus 30-day timeline contained in the regulations will be modified. Many people have given comments as to why that is too short. It should also, the right to offer a commitment should extend up till any such time that the DG's report has been received. Or the third formulation could be that if a party has indicated its intent to offer a commitment, then that indication of intent in itself should be considered, notwithstanding the date on which this provision is finally enforced. So there are two or three ways in which this can be achieved, Shivats, but I think it's important that the sentiment of what we are trying to do over here be acknowledged by both the regulator and the regulated, because this is ultimately going to benefit both.
Sure. So my last question, Samir, how is the settlement framework in India different from foreign jurisdictions? And do you think, since India is looking to introduce this now, are we coming up with a framework which is much better than those in the foreign jurisdictions?
Right. Shivats, look, I mean, to start with, I should say that at the end of the day, we need to introduce that settlement and commitments mechanism in India, which is fit for purpose in India, right? But equally, there is no point in reinventing the wheel. We must look at global best practices when we do so. And I think the single biggest standout point on which many people have spoken, including me, is that perhaps leaving cartels out from within the scope of settlements is really a missed opportunity, or for that matter, settlements and commitments. I think it's important that the government should have, or the parliament should have considered, even the recommendations of the Standing Committee on Finance, led by Shri Jain Sinha, which had recommended to include cartels. And cartels are included as part of the settlements and commitments mechanism in various other jurisdictions. India has, for its own public policy reasons, decided to omit cartels. So I think that is a missed opportunity, particularly given that a number of cases, the legacy cases which are still stuck in litigation, vast quantity of the penalties imposed by the CCI, which is yet to be recovered, are really in cartel cases. So I think the one part, where I feel strongly is that, globally as well, there are numerous jurisdictions who take different approaches, but at least in Europe and even to some extent in the United States, you can, the settlements and commitments mechanism does extend to cartels. And for us not to do so is, in my view, at least a bit of a missed opportunity.
Is this because India wants to keep within its scope only only vertical agreements? Is that the reason?
The settlements and commitments mechanism, and I'm sorry, we should have emphasized this right at the beginning of our program, which is that both settlements and commitments can be offered only for sections 3 subclause 4 and 4. So you can offer them for vertical restraints, you can offer them for abuse of dominance, but you cannot offer them for cartels. And I think, Shivats, if you were to look at the deliberations before the Standing Committee, which I appeared, it would seem that there was a pretty significant push to include, cartels within the ambit. And the only reason I can imagine that the government in its wisdom, or the parliament in its wisdom, decided not to include cartels is because cartels are considered to be the most egregious form of anti-competitive behavior. And it should not be that a party can enter into a cartel, receive its benefits, and thereafter offer either a settlement or a commitment and get away. I think that was the perception or the public policy kind of imperative which led our parliament to make a slight tweak or a departure from what happens in in other jurisdictions. I can't speculate as to what more could have been the reason, since very clearly the standing committee did in fact recommend the inclusion of cartels. So that is going to continue to be an enigma. But very quickly, if I may, Srivatsa, I mean, just in comparison to other foreign jurisdictions, you asked that question. And I think one of the key issues with the draft settlement and commitment regulations, respectively, has really been that settlement applicant or the commitment applicant, the information that they provide in order to try and arrive at a settlement or a commitment is made in good faith. It's bona fide. It's an effort to try and settle a matter or to offer a commitment and complete the matter, right? The draft regulations seem to indicate that that very information which is provided, can be used against the party providing it if they are unable to come to a settlement agreement or a commitment, terms of commitment. I think this is really shooting ourselves in the foot as the Competition Commission, because, of course, we have to incentivize parties to come forward and offer these bona fide applications for both settlement and commitment. And by allowing the Competition Commission to use this very information as evidence against the party who is providing it itself in a bona fide good faith effort at arriving at a settlement, I have a feeling that what we are doing is creating a strong disincentive for parties to even consider this route, right? We should be in some sense laying out the red carpet, because it's not just beneficial for the parties, it is beneficial for us as the Competition Commission as well. And it's useful. France, to name a few, do not allow the regulator to use the information contained in the application as evidence against them. So I think this is an important departure from global practice, which the Commission should seriously reconsider.
Is it because that cartels have a window of leniency, plus that they are now being excluded from this?
So that's an interesting question. It is true that cartels do have a leniency mechanism, but whereby parties who would like to benefit from a penalty reduction can approach the Competition Commission and admit that there has been guilt. If your question is that perhaps one of the reasons why cartels has been left out, so that it does not, the settlements and commitments mechanism does not eat into the success of the leniency program, there, I strongly believe, Shivats, the proof of the pudding is in its eating, right? We have to look at the statistics from other jurisdictions who have included cartels within settlements and commitments and have had a leniency program, and then looked at it statistically and said that has the introduction of settlements and commitments eaten into the incentive to offer a leniency? And the answer, if you were to look at the European Commission, which in many ways is very, our Indian Competition Commission is closely modeled on, and we borrow a lot from the Europeans. If you look at the European Commission, I think the statistics are very clear. Even with a settlements and commitments mechanism, which includes, cartels, the leniency program there has flourished, and there is no evidence, anecdotally or for that matter statistically, to indicate that one comes at the cost of the other. If anything, there has been a recent slowdown of leniency applications in Europe, which arise as a result of the follow-on claims for compensation. So follow-on claims from compensation could have a dampening effect on leniency, whereas settlements and commitments, even if they extend to cartels, are unlikely to, is the learning from the European experience.
Thank you, Samir, and thank you for those wonderful insights and perspective on settlement and commitment regulations. So hope to be in touch in future as well. Thank you so much.
You're welcome, Shrivats. Thank you for having me for yet another very engaging conversation. And I hope your listeners have been entertained in the course of the last few minutes.